Yeah, it's now the time of our lady speaker, Gillian Musgrave. She is a solicitor by education. She works for many, many years in the claims department of the Standard Club, and now she's heading the whole claims of Charles Taylor. Actually, the Standard Club is launched in 2015, a Lloyd's syndicate that is insurance is involved in several classes of business. I mean, she will not speak about claim today, but actually she will give us a presentation of what the Standard Syndicate does in the various segments, and mainly focusing on marine insurance and director and officer liability cover. Gillian, I leave you the floor.
Thank you very much. Well, it's a real pleasure to be here in this wonderful location, absolutely at a conference like this. My first slide, you'll also be relieved to know that my presentation is not too long, quite compact, as we say. As you've just heard, I have moved over from the Standard Club to the Standard Syndicate that the Standard Club set up earlier this year. And it went live on the 1st of April this year, and as the English here in this room will know, the 1st of April is actually April Fool's Day in England, so that was a little unfortunate. However, it's going very well indeed, and we've already underwritten policies up to the value of GB pounds, nearly 19 million. So it's on track, and no April Fool occurred, I'm glad to say. Now, as you can see from the slide, it is a marine and energy syndicate. And the lines that are covered are on the left-hand side: hull and war and IV, mortgages. It's a very soft market for hull at the moment, so it's not a mutual. It is profit-making. So the elements of the hull cover that will hopefully make a profit are more of the IV and the mortgagees interests and war. Energy cover, non-P&I liabilities, wet and dry property, including ports and terminals. Dry property, it would include ship owners' properties that they have, including head offices, warehouses, cargo and specie, and corporate lines, marine errors and omissions, and D&O cover, which I'll be talking to you about in a moment in some more detail. From January, we're also going to be writing political risks and terrorism, and it's not on the slide, but from January 2017, we'll also be writing general casualty. Now, moving on to the main topic of my presentation, directors and officers liability insurance, D&O cover. And this is actually quite topical at the moment in a non-shipping area, actually, Volkswagen. As you will have no doubt seen, they're facing lawsuits. The US discovered that they had devices installed in their cars, rigged to conceal the true emissions of the cars, and this has gone worldwide now. I think that I've read that they estimate 11 million cars have the device fitted. In Europe, 8.5 million cars are going to be recalled. And I read that yesterday there was some action here in Italy. The police apparently raided the offices of Volkswagen in Verona, and also the Lamborghini offices in Bologna. Now, I heard in the market that the D&O insurers are treating this event as a catastrophe event. It's a very large, significant loss in the market, and it'll go straight through the excess layers of reinsurance. They'll be exhausted quite quickly. We think that Volkswagen is setting aside 6.5 billion for fines. Will this be enough? I don't know. Moving on now to D&O coverage. This slide is a an overview, a summary, and I'll talk about the cover in a little more detail further on. Slide A. There's a typo there, actually. It's Side A coverage. Now, Side A cover is cover that could be taken out that relates to the directors and officers themselves. I'll call them the directors for simplicity as I go through the presentation. And this one will kick in, it'll apply in the event that the company who the directors are working for can't reimburse their directors for the legal costs and losses that the directors suffer because a legal action has been commenced against them. A little bit like the legal actions, of course, that will be commenced shortly, or are being commenced against the Volkswagen directors. Side B coverage is insurance for the company itself in relation to the reimbursement that the company has to make to its directors for the losses that they have suffered, for their legal expenses and losses. And I'll be going back a little later to explain about Side A and why the company might not pay. And in relation to Side A coverage, there is no deductible applicable, but there is a deductible applicable in relation to Side B. Side C is insurance cover for the exposure of the company itself, when maybe the company itself is being sued, and of course its balance sheets and its assets are going to be effective. The Standard Syndicate is not really planning to be offering, won't generally be offering cover under Side C, but Side A and Side B will be covered. So why is liability insurance necessary? I think that everything that I was saying about the Volkswagen scenario explains why it's necessary, and so I won't dwell on that too much. But I think it's worth extracting from this slide an important fact. There's no limit of liability for these sorts of claims. Not like there is, where in a shipping casualty, for example, when liability can be limited under various conventions, for example, the Limitation of Liability Convention 76 and amendments. In these scenarios, there's no limit. And it's very easy to run through your insurance cover and reinsurance cover quite easily with a large case. In addition, for the directors who are being sued, they are themselves jointly and severally liable for the damages that could be awarded against them. This slide gives you an example of the types of claims, the types of claimants, and the types of claims that you might see coming in D&O problems. We've got our insured in the middle. Now, I've talked about the Volkswagen case, but I think that in the shipping world, let's have a think about what sort of examples could arise and affect us in shipping. Well, you may have a major casualty where there's a pollution, and an investigation is taking place, and the directors and the directors and officers of the company and the master himself could be facing legal actions for downstream pollution claims. I'm not necessarily just talking about fines here. And you may also find that there are claims from the shareholders of the company. Then another type of problem is sadly relatively common. You may remember in the last couple of weeks there's been a casualty concerning the ship, the El Faro, which was lost east of the Bahamas. I think she went down in a hurricane. Now, in this case, she had on board a 34 crew. Well, she had on board at least 28 American crew members, and I think there was a riding team, a riding gang of Polish, five or so. And everybody's been lost and presumed drowned. Well, it's just been reported yesterday that the family of one of the American crew members is bringing an action in the States. They're claiming $100 million. and they are alleging that the ship owner was negligent and the master was negligent because they could see the bad weather coming. You know, you may remember it went down in a hurricane or a very bad storm. They could see the bad weather coming, is the allegation, but they took the commercial, economic decision to get their cargo, to continue with the voyage because they wanted to get their cargo to its port of destination. And as a result, all these lives were lost. So there was a claim for $100 million out there in the States. Looking at the coverage in a little more detail, the cover gives complete protection to all directors and officers of the company and its subsidiaries on a blanket basis. It's underwritten on a claims-made basis for claims that come in that are made during the period of the policy, even if the alleged wrongful act took place before the policy was incepted. The company itself is the policyholder, and of course the underwriters will ask the company who wants to take out the policy for many details. Now, as I've just said, the directors and officers can be covered on a blanket basis, but they can also alternatively be covered on a named basis. They could be specifically named on the policy. And what is actually covered? Well, it's the defense costs of fighting any legal action that may be launched against the directors, as well as the payment of any amount that's actually awarded against them, whether by settlement or by judgment. And the coverage limit is fixed for each loss and in the aggregate for the policy year. As you might expect, there are exclusions to the policy. And if you have a look at this list, I won't read them all, but they are what I think you might expect. It's possible to carve back into the cover should you choose to take it out. You may carve back if you negotiate it. Perhaps you might want to carve back cover for claims between insureds or companies in the same group. Or you might want to carve back cover for fines and penalties. Now, this is Side A difference in conditions cover. It's a hybrid cover that applies to Side A cover only. And there's no deductible that's applicable for this Side A cover. Now, earlier on one of my first slides, you may remember that I said Side A cover relates to insurance for the losses suffered by the directors themselves when the company is not able to indemnify them. Well, when might the company not be able to indemnify them? Perhaps it could happen when the state law in question, where the company is incorporated, actually prohibits the company from doing this, from indemnifying its directors. Perhaps the company actually is financially incapable for whatever reason of reimbursing its directors or officers, or perhaps it's simply refused to pay. So if Side A difference in conditions cover is purchased, it gives a supplementary cover. This supplementary cover will drop down in certain circumstances, and there are two main triggers for this type of cover. So where the company doesn't indemnify the directors and officers, perhaps the policy limits are unavailable under the main policy because they've been exhausted, or perhaps there's an exclusion because in the primary policy which is kicked in. So that's the first possible trigger. The second possible trigger is actually where maybe the underlying insurer themselves refuses, for some reason, to provide cover because they say there's something that's precluding it, or perhaps the insurer itself is financially incapable of providing it. Hopefully this won't happen very often. One point that's not on the slide that I'd just like to highlight is that this difference in conditions cover only indemnifies the named persons, the named directors, not the company itself. You remember, it's a side A difference in conditions. You will be relieved to know that we're near the end of that, although I hope that you were fairly interested in what D&O cover could offer you. This is my last slide, just to show you the underwriting team of the new Standard Syndicate. I think I've been written down on the program as the active underwriter. Well, I'm not. I'm the claims person, the head of claims. But our active underwriter is Robert Dorry. And then on the next line, you can see the names of the class underwriters for the hull class, the property, and the cargo and specie. I can't actually see all of them, but and the marine liabilities is also Robert Dorry, and the energy class. Well, I hope that that's given you some background, a reminder about D&O cover, and a small introduction to the Standard Syndicate. Thank you very much.
Thank you, Gillian. I think that the Standard Club has entered the market in a period whereby insurance premium are a free fall, so it's great. I mean, that you hit the target so far, and we wish you all the best. Certainly, I mean, we from the industry need new capacity, need new player, and I mean, we will be more than pleased to see you operational for many, many years to come.